In the final November sitting of Legislative Council, members held their second evidence stage on the Assisted Dying Bill, and MLCs heard from two expert witnesses, Bridget Carter and Dr Claud Regnard, as well as the bill's promoter, Alex Allinson. Ms Carter works to prevent coercive behaviour towards vulnerable elderly people, and Dr Regnard is a lifelong palliative care expert. Later in the programme, we'll also hear the advice given by Attorney General Walter Wannenberg on the bill. But first up, Bridget Carter.
Today I aim to share both professional and personal insights to highlight the risks of coercion, duress and undue pressure, and to emphasise the importance of robust training and safeguards in protecting vulnerable individuals. I'm a forensic investigator with UHY Crossleys, where I specialise in financial abuse cases. My daily work involves identifying patterns of coercive control, financial exploitation and undue influence in real-life cases. This includes uncovering hidden abuse tactics such as grooming, gaslighting and trust building that predators use to manipulate their victims. I see firsthand how these patterns develop and how adept perpetrators are at exploiting trust and vulnerabilities. The issue is also deeply personal to me. My late mother, denied the choice of assisted dying locally, became a victim of coercive control, isolated and abused in ways that could have been prevented with stronger safeguards and properly trained professionals. I believe this bill is an important step forward in offering dignity and choice to those facing end-of-life decisions. However, it must be supported by rigorous safeguards and training to protect against coercion and undue influence. From my experience, I know that coercion, duress and undue pressure often follow earlier stages of manipulation. For example, coercion isolates victims through deliberate manipulation. Duress includes explicit or implied threats to influence decisions. Undue pressure exploits trust or dependency to achieve control. Recognising these patterns requires specialist knowledge and training. Without it, professionals could easily overlook or misinterpret the warning signs, allowing abuse to go unchecked. Safeguards and training must therefore be a cornerstone of this legislation to ensure vulnerable individuals are protected and their decisions remain truly voluntary.
There's also a lack of clear statistics which is due to confusion among relevant bodies who often conflate financial abuse with scams and things like that. So of course that's been the financial abuse side of things has been gone on one direction, lumped really with like scams and things like that. That can be referenced in the Financial Exploitation of Elders Research and Scrutiny Support Briefing Paper, February 2023. Yeah, there is, in my opinion, there is a prevalence a lot more. Again, it's hard to get statistics. I did ask the police for statistics, but I never got an answer from them. I did chase it, but I never got that answer. And again, that initial request can be referenced again in the February 2023 paper. There's a lot of information because I have been here before. So identifying it it's difficult because it's not something that's been given its own right. Does that make sense? Financial abuse as averse to a scam. At one point in this paper, the information I put forward is again put forward to the Office of Fair Trading, and they said that these scams they do happen, but not in the UK and overseas and stuff like that. So you're looking at people not recognising or identifying the difference in scams and financial abuse. So that's a massive big problem. Where in fact now we've got legislation in place in the Domestic Abuse Bill Act, you can utilise that legislation in respect of older people, elderly people, vulnerable adults. And I think everybody would agree it's a great idea. The concept itself is a good idea, but it's not going to work with just two doctors because these doctors are not trained in this. Financial abuse isn't just about the three elements that you're talking about, it's about the precursor elements, from the ground up. So you're looking at coercive control from the beginning, sort of get to the trust, building trust with the person. There's the gaslighting, the grooming stages. There's different stages that you build through. Each individual will have his own way of doing that, and then obviously then you've got your coercive control, and you have to be able to see those signs. And it's not just about seeing those signs happening in the person. There's the circumstantial evidence, as you'll appreciate, that shows how that's happened. Things like your wills, for instance, medical records, medication. There's polypharmacy medication. You've got things like diazepam, lorazepam that are given to older people who are in pain. There's a concoction of different medications. That's polypharmacy. So as you're an older person, you're more susceptible to the impact of certain medications than you are anyway when you're younger. These medications can affect cognitivity. They can affect a lot, but also the coercive control that goes behind it. So from the ground upwards, you can make a person more malleable. You know that. You've seen, I mean, for instance, I know it's a bit of a cliche, but bringing in something from the TV, but the latest one was Peter Farquhar and Ben Field, and that was the Sixth Commandment. It was a great effort they put together to highlight, raise awareness of what these abuses can do to people, and that was a classic one. And it's textbook. These abuses are textbook. But unless you're trained to spot the signs, bring them up, it's how can you possibly then say that person is compos mentis? You can do the tests, and that person may appear compos mentis to you because they're filling in the right, ticking up the tick boxes. In my opinion, I think yes, it's a brilliant idea. It is something that I'm for. But unless you can get the correct training in place, I propose somebody like a life trustee. I think a life trustee is somebody a bit like a power of attorney, court-appointed power of attorney. So a court-sanctioned life trustee, who you wouldn't have just one person, you'd have a select group, so a multidisciplinary team of experts, healthcare professionals, who are prepared to undergo that kind of training from the ground up, take responsibility, understand the grooming process from the ground up, looking at the evidence, because you're looking at somebody being coerced. There's got to be a reason why they're being coerced, so you want to be looking for the evidence in respect of that coercion. What have they got to gain? Get to know the family. There's lots of ways that you can ring fence that safeguarding, but it does need to be established. I mean, we train ourselves, we train our people, the people to help us with these cases that we do. So it is possible, it can be done. There's no doubt about that. You can identify, it is detectable, but it's the training. The cases I put together, they're all very much the same. They all run on the same path. They might go off a little bit, differently. It depends what the motive is. The evidence is in the understanding the process, the patterns of abuse. It's the bigger picture, and you're often presented with something that on the outside looking in is, well, it could be either way. You've got to go through, you've got to start from the beginning and work your way through. A life trustee in that situation would be appointed. They would have the relevant training and understanding, and they would automatically connect. So it'd be like a chain of events would start happening. Once that person made that decision, that would go to whoever. I don't know what would it be, as a concept outside of it, but you could envision that chain of events would kickstart the person, the life trustee, who would then automatically be in relation to the banking protocols head that would give the go-ahead for checking through their accounts, that kind of thing. It would all be done very discreetly. I can send you papers afterwards in relation to that, what my concept would be, if that makes it easier for you to look at and understand. But there are a chain of events that would be implemented once that person had made that decision. I don't envisage there's going to be hundreds of thousands of people yearly going to go through that process, but you would if you had a multidisciplinary team, relevant sectors trained in that area, they would be the people that would be able to work together when the time came to kickstart that chain of events. Training's key to every profession. I mean, realistically, you can go to university and do whatever, but you need to be trained. You can hands-on experience. As much as you've got your qualifications, you still need to be involved to be able to get going and understand the process. Training is key, and yes, it can work. We do the training. We've got training set up at work, and we can take it out to the public. We have started looking at advertising and stuff like that for that specific area, for people to even just maybe social workers or somebody who just wants to work in their care profession and wants to be able to spot these signs. We can deliver that training. A training scenario, we would utilise those that are already the public eye, that we would break down from the beginning, as much as I have real life cases that I'm working on that we could utilise without names, obviously. We can show you from the ground up how to spot those signs of abuse. The first training scenario we utilise is the training scenario in respect of Peter Farquhar. A retired teacher entered a romantic relationship with Ben Field, who became a central figure in his life. Peter began to exhibit signs of confusion and withdrawal from friends, ultimately leaving his estate to Ben in a new will. Peter died under circumstances initially considered natural but later revealed to be suspicious. The key points to detect in this case were coercion, and this is what you're presenting to your trainees effectively. So you're giving them a group of different aspects of training, and it's not just about that, it's about role playing. We do role playing. So the key points to detect would be coercion. Ben built trust and emotional dependency while isolating Peter from his support network. Duress, Peter's drug-induced confusion compromised his ability to resist pressure. Undue pressure, Ben influenced Peter to change his will, leaving his estate to him. And there's red herrings we were putting in there as well, so that we could see whether they're understanding the process, because you can go to university for how many years to train as a doctor and come out and not have the ability to be a doctor. So you need to make sure that you're covering all angles, and we wouldn't just use that scenario. There's lots of scenarios, there's lots of involvement, and there's lots of real life cases to show the patterns of abuse, and not just that, but the evidence in respect of going through that evidence from the ground up, your wills, if that's a case, the evidence to show how that will, often rushed wills, often there's so many things to look at that needs to be addressed. But yes, we can do that, and yes, it is detectable.
That was Bridget Carter. The next expert was Dr Claud Regnard. Unfortunately, the sound quality of this recording is not good, but we'll hear now Dr Regnard introduce himself and answer a question from MLC Kerry Sharp.
I'm Claud Regnard. I worked in palliative medicine for over 40 years. I started in 1978 and was Macmillan Cancer Reduce's first medical trainee in the UK. I was medical director at St Oswald's Hospice in Newcastle upon Tyne, where I worked for 29 years.
I'd like to ask both of you if you could design training for a doctor to identify coercion. What would that training look like? What topics would that cover? How long might it take to train a doctor to effectively spot coercion? And I know Dr Regnard mentioned that there is training available in Canada for doctors, but it's it only consists of a few hours, and some of it is online. But other than that, are there actually any other existing training courses which train doctors to spot coercion in relation to assisted dying?
That's Dr Regnard first.
The answer to that is no. And just to go back to the numbers, I'm just looking at a BMJ editorial. The number of elderly, and elderly by the way was defined as anybody over 60, the amount of abuse, and we're talking financial, psychological and physical, it affects 1 in 6. It's a huge number. And doctors are absolutely not trained to detect coercion or manipulation. In fact, doctors' very compassion is actually their Achilles heel in this situation. We're trained to work with families and patients and to believe what is going on. And bear in mind, and Bridget has already really explained a lot of this, abusers are expert liars. They're very good at giving a different story. So it's very easy to get caught into the idea that this is all about training. But I'm sure even with Bridget's people she's training, they would say that if you trainees finish the training program straight as doing a difficult case, you actually need people who've got experience in the situation. So it's actually training plus experience. There are people who have that, and that is social workers and psychologists, and some psychiatrists are trained to do that as well. But I would say social workers and psychiatrists in particular, and I think the idea of a multidisciplinary panel is very sensible. I think you need checks and balances, and that's exactly what's missing in the current medically embedded proposals. A single doctor whose assessment is never monitored, who's doing this on their own. Yes, they're checked by someone else, but they're doing exactly the same process. There's no check and balance in this, and it's in stark contrast to what happens with other life and death and key decisions in healthcare, which are within a healthcare team, where there are checks and balances. And people might say, well, if you were going to use something like a multidisciplinary panel, let's take the example of the parole committee, or in the UK, the parole board. Somebody might say, well, do they never make mistakes? Yes, they do. I don't know about the parole committee, but the parole board has made mistakes. The difference is, we know about them, because their whole process is transparent and monitored, and that's a fundamental difference.
That was Dr. Claud Regnard. The final witness was the Attorney General, and he answers a question here from MLC Paul Crane.
Several sources have warned now that legislation under the European Convention of Human Rights, which I presume this would be, is likely to be challenged if it discriminates between terminally ill adults and other people with serious illnesses or disabilities. Parkinson's comes to mind as a disease where you wouldn't have a terminal prognosis, but you've got a difficult time coming. And the warning has been that this could lead to expansion of those eligible, that the European Convention of Human Rights would not permit this discrimination between these two groups, and that eligibility could move. Is he able to offer a comment on that?
So the current legislative position in the island is that there is a universal ban on any act of assisting another to commit or even to attempt to commit suicide. And that is enshrined or provided for in Section 2.1 of our Criminal Law Act 1981, which happens to mirror the position in the Westminster Suicide Act of 1961. So when it comes to assisting suicide, under the law at the moment, and setting aside the rights under the European Convention, anyone who assists a person to take their own life potentially commits a crime. And so that would apply to a doctor or anyone else who assists a terminally ill person to take their own life. And it is a serious criminal offence, punishable, as I recall, by up to 14 years imprisonment. But it should be said also that it is already lawful for people to commit suicide and for people to travel abroad, to be assisted to do so abroad. The proposed law and the bill before us would expand the range of circumstances in which suicide was lawful to circumstances where, after a statutory process, a doctor prescribes an approved substance with which a person can end their own life. I thought it useful to read into the record also something about the Human Rights Act 2001 in our case, incorporating, as we know, the fundamental rights and freedoms in the European Convention on Human Rights, incorporated into Manx domestic law. The Act makes it unlawful for any public authority to behave in a way which contravenes those rights. This means that all public authorities must ensure that everything they do is compatible with convention rights, unless an Act of Tynwald makes that impossible. People are entitled to expect that public authorities respect their convention rights. It is unlawful for a public authority to act in compatibility with the convention rights and allows for a case to be brought in the Isle of Man courts against the authority if it does so. And so in light of Mr. Crane's question, I have considered how various of the rights and freedoms enshrined in the Convention might be engaged by the Assisted Dying Bill. The first is Article 2, the right to life. If, in hypothetically different circumstances, a law were to be devised by which the state administered a lethal substance, such a law would engage issues under Article 2, the right to life. But where, as here, the state is merely providing a substance which a person may administer to themselves, Clause 7, after a detailed and careful decision-making process, that, in my view, is not susceptible to any challenge on grounds of a violation of the state's obligations under Article 2 of the Convention. I considered then Article 9, the right to freedom of thought, conscience and religion, which I think can be dealt with easily. I see no realistic argument about the freedom of thought or conscience being impacted. Doctors do not have to participate in the process under the bill, Clause 8, and of course individuals do not have to avail themselves of assisted dying. The crux of the issue which Mr. Crane has raised concerns Articles 8 and 14, respectively, the right to respect for one's private and family life, and the right not to be discriminated against in the enjoyment of the rights and freedoms set out in the Convention. It is inevitable that if the Act were passed, there would be some people who would fall within its purview or scope, and some people who were near misses or who might complain as to the differential treatment which excludes them from the ambit of the bill. And the courts talk about the bright lines of distinction, which I'll mention again in a moment. The potential for discrimination challenges has been raised by reference to an argument that restricting the right of a lawfully physician-assisted death only to those with a terminal illness while denying it to others could breach the non-discrimination provisions of the Convention. But for reasons which I will now give, that is not an argument which I can support. Domestic courts in the United Kingdom, considering human rights challenges to the existing law on assisted dying, have applied a principle that there are strict lines of institutional competence, whereby the courts will not interfere with the decision of Parliament as to where to draw legislative lines. No less an authority than the UK Supreme Court in a case called Nicholson in 2015 held that it is for Parliament and not for the courts to determine the scope of legal rights in the case of assisted suicide. The mere existence of bright lines or distinctions between those who can and those who cannot benefit is not a basis for a discrimination claim. The law recognises in many contexts the legitimacy of bright lines as to who is entitled to a benefit and who is not. I mentioned, as an example, pensions. In a 2008 case, the Appeal Court in England and Wales held that, and I quote, legislation cannot be framed so as to address particular cases. It must lay down general rules. A general rule means that a line must be drawn, and it is for Parliament to decide where. The drawing of a line inevitably means that hard cases will arise, falling on the wrong side of that line, but that should not be held to invalidate the rule if, judged in the round, it is beneficial. If, despite what I've said, the court were asked to consider a discrimination challenge to the legislation, to our bill, it would ask whether an interference with an Article 8 right or an Article 14 right, read with Article 8, is proportionate. That turns on whether the interference pursues a legitimate claim, whether the interference with the right is no more than is necessary to accomplish an important legitimate objective, and whether it strikes a fair balance between the right of the individual and the interests of the community. The relevant right to respect for private life consists in being able to determine the time and manner of one's own last days and the manner of one's death. Even in the improbable event that the courts did determine that there was a breach of one of these convention rights, the remedy would likely be a declaration of incompatibility under Section 4 of our Human Rights Act. And the effect of that is to send the legislation back to Tynwald to reconsider the original legislation. Notably, a declaration of incompatibility does not affect the continuing validity of the legislation, and Tynwald would be under no obligation to change the law in light of such a declaration. A word perhaps finally then about a challenge in the European Court. In any onward appeal to the European Court of Human Rights, an appellant would face the problem of the doctrine of the margin of appreciation. The European Court of Human Rights has repeatedly said that legislation on assisted dying is a matter within what's called the margin of appreciation of the member states of the Council of Europe, and therefore not a matter with which it will interfere. That principle has been recently restated by the European Court in relation to a case concerning assisted dying, with judgment given just in September this year, where the court noted again the considerable margin of appreciation afforded in respect of these arguments. The margin of appreciation is a principle applied by the Strasbourg Court in recognition of its place as a supranatural court, laying down for individual member states what might be described as a bare minimum standard in complying with human rights. The wide margin of appreciation enjoyed by member states, as has consistently been invoked by the European Court in this context, does mean that, in my view, there would be effectively little or no prospect of a challenge to the bill as presently drawn. And so I conclude by saying that if the Assisted Dying Bill 2023 is enacted, in my view, any human rights challenge to those new provisions would be unlikely to succeed in domestic courts. There is a clear line of authority that decisions in this area are for Parliament and that the courts will respect Parliament's decisions, including any arbitrary or differences in treatment which result from the bright lines drawn by legislation. One might think that that is particularly so where new legislation has been recently adopted.
That was the Attorney-General, Walter Wannenberg. So what do you think? Are you concerned about the impact the introduction of this legislation will have on society? Or perhaps concerned that it's not being introduced fast enough? It seems increasingly likely that the bill will be passed in some form by both branches, so assisted dying is something we will all need to get used to. Let me know your thoughts on the programme by contacting Phil Gorn at manxradio.com and get in touch if you have any ideas for future shows. Don't forget, this programme is available as a podcast on Manx Radio's website. For now though, I'm Phil Gorn. Go to Mayo. Thanks for listening.